So everyone grabs a seat when we get a chance. We like to start up. Everyone having a lovely day so far? Fantastic. Thank you for braving the lovely weather. We're excited that it stopped raining so everyone can get here safely. Thank you once again. My name is Mike Rondelli. I'm the Associate Vice President of Innovation and Commercialization from the University of North Texas. We're very proud to have you in our building here for the next Inspire Frisco talk, which is lovely. We have a special guest. We have the Director of the Dallas office of the USPTO, Hope Shimabuku. Thank you very much, everyone. Give her a round of applause for coming out. She braved the weather to come from Dallas to here. Really excited. Hope runs the Dallas U.S. Patent and Trademark Office, which is incredible. We only started having more than one office about 3.5 years ago, October of 2015?
November 2015. Well, we started, actually, to clarify, we started having new offices opening up 6 years ago. Yeah, so my office opened in November.
But it's Dallas, that's the important one.
Yeah, that's right. I agree.
So we're really excited to have her here talking about how innovation's impacting this region, why the Dallas office was opened, and all about patents. And it's something that we know is an incredibly important thing for the innovation ecosystem, certainly from the university's perspective, but from startup companies as well as large companies and how they spin off entities and how they purchase entities. So we're going to start off talking a little bit. We did have one question to start with, but first we want to go through just everyone here knows about Inspire Frisco. We're the Innovation Ecosystem Program starting here in Frisco for the entire North Texas region. This is our monthly programming for networking. We also offer network mentoring for free, where we've had over 75 companies mentored so far since December 1st. We've got some other spin-out opportunities and other programs, including a university spin-out exchange, USpinX, which takes all the regional universities and have the technology transfer day for both industry and entrepreneurs to meet, find technologies, take it from the lab into a company's bench, and then maybe incubate it in a building like this and meet venture capitalists. Otherwise, here we are to start. Who here is familiar with intellectual property? Stephen, raise your hand. So everyone here is familiar with patents, trade secrets. Anyone here ever have a patent? Anyone listed as an inventor on a patent? Okay, so not as many. So we're going to go over a little bit of the basics as well, but also really go for, we've got a middling to advanced level of people here. Obviously, some people are very advanced, but we want to make sure that everyone gets a cross-section of what intellectual property is and all that the USPTO does. So with that, should we start off with, what is the USPTO and why are they in Dallas?
That's a great question, Michael. And so also I wanted to bring up that I'm fairly easygoing, and so is Michael. So if you do have questions along the way, we're happy to take the question along the way. I do have a question. Do they need to speak into the mic when they have a question? I'm guessing the answer is
yes. Josh has a microphone in the back, and he's willing to walk around and Phil Donahue, everyone.
Okay, so if you do have a question, please raise your hand, and Josh will come over and hand you a microphone. But just to give you a broad overview, the USPTO is headquartered in Alexandria, Virginia. We have about 12,500 employees, with the lion's share of our employees being technical in background. So 80% of our employees examine patents, and so they are the largest group in the USPTO. We also have a huge group of trademark examining attorneys, and they don't usually have a technical background because they're not evaluating things on a technical basis, but they are reviewing your brands, your logos, the name of your companies, and determining whether you should get a trademark or get trademark registration across the country. And so we also have a huge bevy of judges, both on the patent side and on the trademark side. And so with respect to both of them, if you have something that you don't agree with what the examiner had said, or even if the examiner issues a patent or a trademark and you still disagree, you can bring the matter before the judges within our office as well, being the USPTO in general. So as Michael mentioned, we are here in Dallas, but we also have 4 other regional offices across the country. Our first office opened about 6 years ago in Detroit, and then it was followed by offices in Denver, Silicon Valley, and Texas. And so the Dallas office is actually the last office to open. I always say that we've saved the best for last for opening. And so what you see actually on display over here is a map of how the United States has been broken down with respect to each of the regional offices as well as headquarters. What I want to clarify, though, is that each of the states that each of the regional offices are responsible for, we are responsible for them from an outreach perspective. So as a stakeholder, if you are in our particular region or you have an event or you want to meet with the Texas regional office generally, then we are the office that is going to be responsible if you are in that particular state.
And Hope, just to be, one of the things that I thought unusual, because I lived in California for so long, and you wouldn't think it's a fly to Alexandria to ask a question, but I could just make an appointment and show up at the interoffice in Dallas and be walked through as an individual inventor what resources are available, how to be able to do patent searches or trademark searches directly in your office. So it's a 30-minute drive, 20-minute drive to go do that right here in the region.
Yeah, that is exactly right. And so you actually don't even necessarily need to make an appointment. As long as it's during the regular business hour, you can actually walk in and ask for help on a regular basis, whether it's patents or trademarks. So we had an example, actually, I was sharing with Michael earlier this week. So Monday morning, we had a gentleman and his family drive up from Houston. They were of Chinese background, but they came up and they found out that we had an office, and so they had questions about the patent application he wanted to file. The only reason that I specifically knew about this is because his English was not very good, and I do speak Chinese, and so I was there to help interpret and to speak to him and walk him through the process. So because the USPTO is very diverse, we have a lot of backgrounds, we're able to provide services like that, and there's many people in our office who can speak different languages to help different stakeholders who have questions.
Oh, that's great. And again, I think it's an important thing to point out how important the PTO is to the U.S. economy. Mm-hmm. So how many people here know that the issuance of patents is in the Constitution? So it's, okay, so a couple of us do, yay, but very few people realize that it's in the actual Constitution. So how has it shaped the country, and why is it here in Dallas to help shape our economy here?
All right, well, and that's a really good question. And so one of the things that we like to say is that there is a symbiotic relationship between the U.S. economy, how well it's doing, as well as intellectual property. We know that there is a tie when one is doing well, the other is doing well. And so if you look at the numbers from a 2014 report, which is the most recent report that we have, we know that intellectual property accounts for almost 40% of the entire United States GDP. Those who own intellectual property or who work in the intellectual property industry tend to make more money on average than those who are not in those particular industries. And from a legal standpoint, we've seen about $115 billion in revenue across 28 different industries. Now, Texas, as you probably can guess, is no different. We have been a huge beneficiary of intellectual property just in general. Lots and lots of money spent on R&D, $22 billion annually spent in Texas alone. We are the #1 exporting state out of any state in the country of intellectual property. So lots of things that are produced in the United States are being shipped out internationally from our ports down in Houston. Did you know that Dallas actually also, DFW Airport is the second largest largest airport in the country. And as a result, lots of shipments are going out of what we consider as the Port of Dallas, going out and shipping. And so Texas is huge. It's a huge beneficiary. That's one of the reasons why the USPTO had placed an office here. We saw all the technology companies that were building up. We also saw the potential of new technology and new startups like groups that are formed here and Inspire Frisco. That was another reason why the USPTO placed an office specifically here in Dallas.
That's fantastic. And I would imagine our concentration of Fortune 500 companies can't hurt either.
Yes, definitely not.
So does our office, your office here, does it focus on the industries and the technical areas that are more focused in this region?
That's a really good question. And so we actually are not focused within each of the regional offices. As I mentioned before, each of the regional offices, although we have responsibility for outreach of certain states, that does not mean that we have responsibility for the filers in those specific states. So if you are in Texas, for example, and you have a patent application or a trademark application that you're going to be filing, it's not necessarily going to be reviewed in my office. And there's a couple of reasons for that. As I mentioned previously, one, we have 12,500 employees worldwide, not worldwide, excuse me, US-wide, we're the US government, so US-wide. 8,100 of them are patent examiners, and over 50% of them work from home. And so Texas is the second largest filer of patent applications out of any state in the country. And so on a regular basis, Texas is seeing over 20,000 patents every year granted to Texans. And so my office with 150 hired examiners, we can't simply even cover the state of Texas. And so what happens is that we have a huge variety of technology areas that are hired within my office. They're hired based on need and the technology area that is needing hiring. And so sometimes your patent application will be reviewed in my office if it's in a specific technology area, but not necessarily the case.
Okay, that's great. And I think that's an important thing for people to understand is that you use technology throughout the entire patent prosecution process, and the examination process itself is about experts.
Right.
And that might be something, should we maybe talk a little bit about how it focuses a little bit on how the patent prosecution goes, or do you want to talk a little, how about we talk about the Texas economy first? Let's talk about that.
Okay, all right, so we tried to organize this.
That was it just was a really good lead into how it changes the economy based on how specific it is, but certainly how it impacts the Texas market. So we know that, you know, Frisco is the fastest growing city for large corporations in America for recruiting companies, and the city rated best to live in the United States as well. But our intellectual property, as you already mentioned, we're the second most prolific state for filing intellectual property. What areas are we really great at, and how does it impact our economy?
So from a technology standpoint, Texas has historically always been a heavy oil and gas state. Probably doesn't surprise you. So from a technology standpoint, from patents, we see the most oil and gas drilling, specifically patents within the area. But within the DFW area, we've been seeing a huge number of semiconductor patents, and we also have a huge number of telecommunications patents. And so in case you're wondering, how many of you have a guess on how many patents are granted per week in DFW? All right, okay, I'm gonna take a poll. How many of you think
58.
5? Okay, 58. How many of you think less than 58? Okay, how many of you think more, around 100 maybe, per week? Okay, so it's not quite 1,000, but we have about 130 to 140 patents every single week coming out of the DFW area. It's amazing how many are coming out. And then when you're looking across the entire nation on the top 20 cities that are producing patents across the board, Texas has 3 of them. DFW, Houston, and Austin. Actually, they're in the top 10 regions. And from a filing perspective, they're only like 100 patents apart. And so Texas is, yeah, isn't that amazing?
Because Los Angeles, population-wise, is like 1,000 times more people than this region.
Yeah.
I mean, just huge. There's like 100 million people who live in Los Angeles, or at least are on the highways at any one time. As someone who lived there, so that's amazing that we're that productive, and that must have just a huge impact. So it goes back to those dollars that you were showing before. I would imagine a huge amount of the value that's growing here in our region comes from intellectual property and is going to allow us to continue to grow. Is that?
Absolutely. And I think with other companies that continue to come in, I mean, Dallas has always been a huge financial industry. I mean, they're saying that we're going to be taking over Wall Street numbers fairly soon. And so there's actually a lot of technology that is associated with the computer programs and different things that are being automated across the board right now in the financial industry. With Toyota moving in, I anticipate seeing automotive patents when we didn't see those previously. But companies like that are coming in, because when Toyota moves in, or State Farm, or any of the other companies that move in, it's not just that company moving in, it is all the other small companies that are there to help support that larger company, and they are also innovating across the board at the end of the day.
And the universities to go get that into them. Yeah, we're trying.
Yes, no, I agree. I mean, the universities are huge. I mean, they are huge partners across the board, because you are the research arm for a lot of these corporations, and they do look to you for that research. And at the end of the day, look to you to file the patent at the end of the day. And
usually want us to pay for it too, which we try to figure out another path around.
That's a different topic.
Yeah, it's a different topic completely. We could talk about that some other time, and usually over drinks. So that's fantastic. I think that really shows a lot about why it's important to have it here. You've grown your office really quickly. When I came here, I think you started with, I remember you had 45 openings the first month that I started that you were trying to fill, and now you're already at 150?
Well, that's just patent examiners, you're right. And so we're full. And so we've hired 150 patent examiners, we hired 20 patent trademark judges, and then support staff. So we are full right now.
And how many matters do they deal with per year on average? I know they keep a caseload.
Yeah,
that's pretty substantial.
It is pretty substantial. I'm actually not sure on the numbers on that, but just to give you an idea, we receive as an agency, we receive 650,000 patent applications every year. And so we are processing through that every single year. Now, we do have a backlog of 550,000 patent applications, but believe it or not, that number has not been going up. So that number continues to go down. So we are chipping away at that. We granted our 10 millionth patent last year, and so it is an amazing feat. But from a filing standpoint, we are seeing an exponential rise in patent application filings within our office.
That's fantastic. At least I hope it is. It's not a good workload, but for everyone who's in the office, at least they know that they've got some job security of more things coming and going.
Oh,
and I do know that the time for processing patent applications has dropped dramatically over the past 15 years.
Yes,
especially with expedited patenting.
Right.
Expedited prosecution.
Right. And so you have the option of expediting patent prosecution, in which you can pay an extra fee, and you can get your application reviewed and processed within a year. On average right now, we are averaging about 24 months from start to finish, which is huge, because we used to be at 36. And it wasn't that long ago, maybe 5 or 6 years ago, we were at 36. And so we've really been chipping away at that lead time. And opening the regional offices has really helped, because we've been able to hire the people that we need to be able to support the examination of that review.
And I'm sure that's had also that impact in the growth you've had on impact on the economy, because when people know if their intellectual property is valuable, then they know that they can actually commercialize it.
Right.
They can make the investment into it. They can hire people around it. They know that it's defensible, that they can spend all the money in getting changing machinery to start selling a new product of some sort. and be able to reap the economic benefits.
Right. I mean, one of the things that I'm actually going to flip to those slides. Oops, wait, I'm going the wrong way. So one of the things that we are aware of is the advantages associated with having intellectual property. And so from a patent standpoint, we know that once you get your first patent, there's huge benefits from that. Once you see in the first 5 years, there's huge employment increases. You see increases in sales growth. And there's a couple of reasons for that. When investors are looking at you as a company and whether you own intellectual property, they see a couple of different things. They see the money that you've invested in it and that you have a plan because you have invested in property. At the end of the day, intellectual property is exactly that. You can do the same thing that you could do with what we call real property, like your house or your computer or anything else. You can sell it, you can give it to other people, you can give it to your heirs, you can transfer it, you can rent it out, as we call it, licensing. And so it is like property. And so there is a value associated with that intellectual property. So what happens after you get your first patent is that investors realize that the likelihood dramatically increases that you're going to have additional patents, that it allows you to facilitate access to capital at the end of the day because it'll reward investors because you've seen the investment in property already. And so what we've seen from a number standpoint is that it's increased about 53% the probability of what we call VC funding. And there's also a small increase in the likelihood at the seed round, but then there's a 47% increase in the probability in the second round of funding. And so it provides you capital access at the end of the day.
That's really interesting. So 53% increase in probability of VC funding is amazing. I mean,
right.
Any one thing that can get you more than 1% more likely, I would be willing to pay out the wazoo for. And certainly only a little bit in filing fees is not very much to pay.
Right.
Because you're raising a lot of money that can make a huge impact on your company. So I would imagine that that just really drives it. And as the innovation economy and the venture economy understand this, that must make it so much more vibrant for the USPTO.
Yes, yes. And then I think what happens at the end of the day is not only at the beginning, right? So when you're getting the money, the statistics have bore out the fact that you will more likely go IPO. You'll more likely be acquired at the end of the day. And then I hope that this never really happens to you, but at the end of the day, what the investor sees that what happens if your company goes defunct at the end of the day. Does anyone know who Jawbone is?
Was?
Okay, so they were the competitor to Fitbit, right? They were the first ones actually who invented a Fitbit-like device that can track your exercise. And so, but we don't know who they are. And so they dissolved. They were not successful from a commercial standpoint, but what was left at the end of the day was their assets, their intellectual property assets. And the value of that intellectual property asset ended up being $25 to $40 million at the end of the day. So when the investors are looking at your company, your future company or your startup, they're not just looking at the straight patent and the value of having the patent. They're hedging their bets because at the end of the day, they're like, well, what if you do go defunct? What is left at the end of the day? And one of the things that is left is intellectual property.
That's great. And I think this probably goes back to where we had before with the next step, which is defining the different types of intellectual property. Mm-hmm. We talked a lot about patents, which is the easiest one for people to get an idea of, although it tends to be the most misunderstood, mm-hmm. At least from my experience. I'm sure that you have a lot of experiences with that as well. Let's talk about the basics of patents, how long they last. What's the most common misconception that you've heard for a patent?
So I think that there is confusion at the end of the day on the different types of patents, right? So there are two main types of patents in the sense that we talk about provisional patents and non-provisional patents. So there's a misnomer in the sense that people think that if you file a provisional patent, that you're going to get, it's considered a mini patent, and that you'll get a patent at the end of the day, which is not the case. A provisional patent is really just a placeholder at the end of the day, because it's a race to the patent office. Whoever files their idea with our office first, they're the ones who end up getting the patent at the end of the day. And so if you're trying to be first to market and you're trying to be out there, or you're just trying to raise capital at the end of the day, a lot of times a provisional patent, which is a shorter description or a shortened version of the patent, is a great way to start. But a provisional patent will never convert to a full-blown patent. You have to file the full-blown patent, which is called the non-provisional patent, and that's the one in which your rights will actually accrue once that patent is granted.
And have you seen a big uptake in provisionals after first inventor went to first to file? Because we went first, we became first inventor to file after the American Invents Act.
Right.
And because of that, you couldn't fight and say, I invented this but never told anyone years and years ago.
Right.
Now with provision, but it made it so that if you filed the provisional early, you've now set in stone, I'm the first inventor to file. And because I've got that priority date that I set with my filing date. Did you see a big uptake?
You know, I don't know. That's a really interesting question. I would like to think that we did, but I haven't really looked into it. But the United States is very unique in the sense that we are the only place that allows you to file a provisional application, to essentially put a placeholder for you to get your patent at the end of the day. And so I think that that's really unique that we allow that in the United States. If you go to another country, there are different rules there. And so they don't necessarily allow you to do something like that.
And also, I think it's good also to mention that a provisional patent is probably the best way to move. But in America, in the US, we also have the ability that if you by accident disclose it, like we put the slide up here right now, that is my new invention, and I enable people to read it, I don't lose all my patent rights in the United States that day.
That's right. So you have a grace period of 1 year before you actually have to file your patent application with us. And so if you are at a trade show or you are presenting your thesis statement for the university professors, and you are presenting it to the public, you do get a grace period of 1 year before your first disclosure, before you actually have to file your patent application. You don't get that in other countries. And so once you disclose, that's done. It is meant that you have told everyone and you have shared your idea with everyone, so now everyone is able to use it, and you are publicly disclosing that.
Right. And once a patent has either expired or the patent rights have, the year grace period has expired, it becomes public domain, correct?
Right.
So you no longer have a claim. You don't own that anymore. You may have been the first person to say it, but you do not own it any longer.
Right. I mean, the idea is it's a trade-off, right? We give you a monopoly on your invention for 20 years. And then after that, you share it and you advance and you promote your idea to advanced technology so that other people can use it after 20 years. And it's proven to be very successful. I mean, if you look at patent number 1, ironically, patent number 1 was a wheel, okay? And so, you know, they said the wheel is the mother of all inventions. Well, it was, because it was patent number 1 in our office. And so, but we've moved away from the wheel. Now, are there still wheel patents out there? Yes. I mean, as we get new rubbers and different things that make the wheel more efficient or have better friction in rain, for example, we do continue to get those, but we've advanced the technology beyond that and we're able to use it more.
And what about trademarks? Or what's the next one that
So trademarks is a great question. Let me go to that slide. Okay, so trademarks is actually a source identifier. So it tells you who is providing the good or service that is associated with that mark. Now, it can be a name, it could be a logo, or it could be any of your senses. So for example, it could also be a smell or even a sound. And so one of the trademarks that we have listed up here is fixer-upper, right? So everyone knows, or at least those who watch the TV show, know who fixer-upper is. If you want to get your house remodeled or fixed up, you would go to them to go to fixer-upper. What you also know is that if you want to go buy a new car or a new tennis racket or a new cell phone, you're not going to go to fixer-upper to go and get that. You're going to go to another store that is providing that particular good or service that has a different trademark or a different name associated with it.
And I know that the next one is the one that's the hardest for people to understand about whether they need to register or what the actual control is, but a copyright.
Yes, so copyright is actually not managed by my office. And so my office manages both patents and trademarks, but the U.S. Copyright Office is the one that actually manages copyrights. And so a copyright is an original work, and it's typically artistic, that is embodied in a tangible medium. And a tangible medium can be pretty much anything. And so if you have written something and you've written words down, and it is a creative work, and once you put it onto a piece of paper, your copyright attaches to that. Similarly, if you write that book onto a computer, right, once you hit save and it saves to the hard drive, that tangible medium is the hard drive, and it is saved there. And so anything that you typically see, sculptures, or you see music, anything that's saved on an MP3 player, the musical score on the piece of paper, all of that is all considered copyrights. And because it attaches immediately when it is in the tangible medium, you don't actually have to register it with the U.S. Copyright Office. There are advantages to that. So you do want to register it if you think that you're going to go international, for example. And so what you can do is once you register with the Copyright Office, you can also register with the Customs and Border Patrol. And so that when a knockoff comes in overseas on your product, then Customs can stop it from coming into the United States to be sold. That's one of the biggest advantages that you have.
That's great. And then trade secrets, we are state law, mostly. Mostly. Some federal, some state.
Yes.
And no one really manages it besides people suing each other.
Right. So one of the things with the government is that if you let us know anything, it becomes public, right? And so a trade secret is there's value in something kept secret. And so the most famous trade secret is the Coca-Cola formula, right? And so no one really knows how to make Coca-Cola. Coca-Cola has tried, or other people have tried to figure out the Coca-Cola formula, but it's been not successful. Similarly, in the Texas area, Dr. Pepper, right? Founded, originated in Waco. So there is supposedly 23 ingredients in Dr. Pepper. No one really knows what the secret 23rd ingredient is. And so that is a trade secret that has been held for a very long time.
My favorite is from my hometown in Hackettstown, New Jersey, is how you print M&Ms on M&Ms before we had laser or inkjet printers. Because they've been doing that for almost 80 years now, and that was metal hitting up something.
A candy.
And that would be bad for the candy.
Yes.
Yes, bad for candy. So, but that means they also lost an entire industry. So you could have had HP based in New Jersey, because they missed out on the LaserJet or the inkjet printer.
Oh, yes, you're
they
right.
missed out on an entire industry because they kept something a trade secret instead of filing a patent on it back in the 40s.
Right, right. And that's a question at the end of the day for any business, right? Whether you want to keep something as a trade secret or a patent, they're considered polar opposites. And so if there's something, so the thing to remember is that a patent only lasts 20 years, but a trade secret will last forever as long as you keep it secret. But the key is keeping it secret, because once the secret's out, then it is out.
Absolutely. So I think that this is great, and it's been great talking about this. I know we have a lot of questions, but I think ending on how do you think this region is going to grow with intellectual property, and how do we all play together to make sure that we use intellectual property as a true asset that you've shown statistically is worthwhile in making an investment in to be able to grow our economy? How do we see it growing? How do we work together to continue to grow it here?
So I think Texas is growing by leaps and bounds. Someone actually told me the other day that right now Texas has 45% of the nation's jobs in the country. And I don't know if that statistic
Are they all coming to Frisco?
A lot of them are. Now, whether that is true or not, I am not sure. But what I think it is indicative of is just how much growth and economy that we're seeing. And along with that is the huge amount of technology that is coming with it. And so for cities like Frisco and the greater DFW area, there have been a lot of companies that are coming in. They're moving headquarters into our area. And so we're seeing all of that growth and lots of patent filings that are associated with that.
Fantastic. Thank you so much for that. Now let's have you all reach out and ask some questions. Wendy?
Okay.
Oh, yep.
Yep, the mic.
I'd like to know where you should start. Like, should I start with a lawyer and a patent attorney and then come to your office, or should I start by reaching out to your office? Like, what's the first step?
Okay, that's a really good question. One of the things that we usually recommend that you start is do your own search. As an entrepreneur or startup, I know that you are fairly independent and you like to do things yourself. Start with a search for, if you're doing a trademark, make sure no one else is using your name in your line of business, okay, or using a symbol that is very similar to your line of business. So you could go onto our website to do searches there. You could go do a simple search online, like using the Google engine to be able to do that. For the patent side, that is also a good idea as well. Go into Google Patents online, take a look to see if there's something similar that's already been invented. I do recommend that you do find a lawyer to help you, because from a trademark side, it can be deceptively easy. So your initial filing is not that complicated, but whatever you file is kind of what you're stuck with at the end of the day. And so when you get a response from our office, then that's when the confusion comes up. And so if you do have a lawyer that is there, they can help you with that. Now, from the patent side, I would definitely say get help. There are a few people who are very savvy at being able to write your patent application, but it is very, very difficult. And so all of these little nuances can kick you out of the system unintentionally. And you've invested so much money already into this, why not invest a little bit more into it as well?
I think a thing to add to that is that most of the cost of a patent issuing in the United States is spent on your attorney, not on the fees from the USPTO.
Right. And so the attorneys, so let me give you a range, and Kelly may not like this, but so with the USPTO, it's going to cost you about $1,200 for what we would call a plain vanilla patent application. Okay. So that's for the large corporations. You get a 50% break if you're a small company. And then if you're qualified for a micro entity, you get a 75% break. So a micro entity is a small, if you fall below a certain income threshold and you don't have more than 5 patents with you listed as an inventor, okay? So where I've seen when I was practicing is that attorney's fees can range anywhere from $8,000 to $30,000, okay? $30,000 typically is you found the cure for cancer, all right? So the pharmaceutical companies have spent a lot of money, a lot of R&D in it, so they're going to spend a lot of money protecting their intellectual property and their patents at the end of the day. Now, it is a lot of money, but it is well worth it for you to do that because of the complication of the system. There are different things that you can do to help reduce those costs, and doing a search on your own typically helps you reduce those costs, because at the end of the day, it's time, right? How much time is the attorney spending on working and trying to figure out your patent and preparing your patent application? Now, we do have free resources as the USPTO. So, for example, we have worked with a number of the law schools in the area, and they've set up clinics. So the clinics at Texas A&M in Fort Worth, that law school, as well as SMU Law School in Dallas, both of them have both trademark and patent clinics, in which it is students who are working on your patent application but are supervised by a local attorney. And so we also have pro bono organizations that we've partnered with. And so in the state of Texas, we've partnered with the Texas Accountants and Lawyers for the Arts. They are located in Austin. Now, you do have to fall below a certain income threshold to qualify for those pro bono services, but they are options that are available to you if you can't afford an attorney at this time.
Thank you.
Hi, I'm dealing with a little bit of a trademark dispute with a much larger company. Are there any resources available just to get some unbiased feedback? I'm working with an attorney, obviously, but I haven't found his insight thus far to be super helpful.
So when it comes to enforcement or litigation in this particular case, we do have a couple of resources available, but they're general resources. So they're going to be resources online that tell you about trademarks, some of the different procedures that we have if you have a dispute. So for example, an opposition or a cancellation, those types of procedures administratively that you can do with our office. So you can find that information online. We also have a 1-800 number that you can call, but the majority of the people who are going to be answering that 1-800 number on the trademark side is really going to be those who are helping with the filing of the actual application. So we don't have a lot of resources from an enforcement standpoint. Your attorney is really going to be your best resource, but we do have general information if you're looking for basic trademark information online.
Hi, I'm Pablo Schneider, and I actually have that job reference for you for Texas, and it is that Texas was largely responsible for the 1.2 million net U.S. job increase since '07,
Wow.
and that's over 8 years, and that's
Wow.
a fact, is that the rest of the country kind of broke even, and that Texas was responsible for the net job creation nationwide and it's been that way for many years. This is a 8-year period. Glad to send it to you, and
Yeah, that'd be
that
great.
way you'll
I'd
have
love to see that
And my
information.
question has to do with patent trolls. So there's a big kind of controversy in the media, and people hear about patent trolls, and are they good? Are they bad? Are they ugly? Why are they? How do they make fortunes? And that kind of thing. So I thought it'd be kind of a fun question to ask you on that one.
Okay, so how many of you know what a patent troll is? Okay, so a patent troll, the reason that they got that name is, let's just start with what they are. So a patent troll is someone who owns patents, but they don't produce anything, or they don't provide any services, and they don't provide goods, okay? And the only thing that they are doing is seeking royalties or fees for using the patents that they own. So they're seeking licenses. And so patent trolls, at the end of the day, got their name because they were trolling around looking for money, and they've been typically hitting the large companies at the end of the day. Now, I want to distinguish this, especially since UNT is here, because as a university, they're typically not a provider of goods or services, but they do own patents, and they are a licensing entity at the end of the day. We're not talking about universities. We're talking about those who are almost abusing the system and trying to seek money sometimes not in the best way. And so what happens is that they are filing lawsuits against the larger companies, and larger companies at the end of the day make the decision not to move forward with litigation because it's more expensive with the litigation, so it's easier to just pay the patent holder than to fight the patent holder, and that's what the patent trolls are gambling on, right? Making that easy win. Now they've gotten a lot harder to do this type of business model because they started going after some of the smaller companies, and so the mom and pop shops. And so when I was at Xerox, one of the patent trolling companies were suing people for scanning technology. So if you had scanner and you were using Wi-Fi, which is almost everybody who owns a scanner and had a business, then they were coming after you. They're sending you a letter says that if you pay us $10,000, we'll go away. And so a lot of the state attorney generals got involved and were upset with this particular situation. Now, I don't want to give the misnomer that it is a legitimate model of doing business, and they are patent owners. Unfortunately, because of the way that they've abused the system, they've gotten a really bad name. And Eastern District of Texas, which is out in Marshall, a lot of the litigations were happening there as well. And so it is very prominent in the Texas area.
And UNT does not engage with patent trolls in any activities. We only try to license to practicing entities to increase jobs and increase productivity of especially the North Texas region. I'm required to say that.
I have a million questions. Let me start with the most trivial of them all. Is it really true that people are still filing patents for mousetraps? And do you guys laugh out loud every time you get one?
So we get patents for all sorts of technologies. And so, yes, I mean, there are people who are still filing patent applications for very simple inventions. So but then we also get the very, very complicated inventions. We also, and this is just something to laugh at, there in a patent, if you study it, there's a section called a claim. All right, so we get claims sometimes from people that says, I am God. And so that's the patent application that they file with their office, and they claim that I am God. And we're like, okay, well, that doesn't get you a patent at the end of the day. But yeah, we do get those very simple inventions. Some of the inventions we get, things that I like to say is, you can file a patent application, but the requirement is not that it be a practical application.
Except? Right? No, there's one practical one that we have to give an example for. Perpetual motion machine.
Oh yes, okay, yes, there is. I mean, there are lots of very practical ones. One of the impractical ones that I like to say is that there is a fire escape patent, and what it is it's a helmet in which there's a parachute that will come out of the helmet and when you have to jump out of a building, and then they have rubber shoes at the bottom with a really thick sole, so you can land on this really thick rubber sole. Now, the thing at the end of the day is once that parachute launches, you might get decapitated at the end of the day, right? So it's not practical, but it is a patent application nonetheless. No one else has invented that. And so.
For good reason. Let's hope that. I certainly don't want to practice that one. That's not a good one. And if you're infringing it, you probably only infringe it once. I think we have time for one last quick one. Does anyone else have another quick question? Anyone else? You have another question?
So this one's on a little bit of a more serious note. So there's a lot of discussion around business circles that the number of technical patents from the United States as a percentage of the overall patents globally has started to decline. Mm-hmm. From the perspective that, well, compared to new patents being issued from elsewhere in the world, from the perspective of your office, where you get to witness or kind of firsthand the total number of patents coming in and the likely commercial impact of those patents, what's your perspective, or perhaps do you even have one? How's this playing out to the overall competitiveness of the U.S.?
So from a number standpoint, you're right. I mean, the percentage of patent applications that the United States grants relative to the worldwide patents has gone down. And there's a couple reasons for that. I mean, the United States really invented the patent system, right? So we have been and we continue to be the number one around the world. But as other countries are coming up and their patent systems are improving, they are increasingly issuing and granting more and more patents. Now, the one country that is really skyrocketing is China. And so that probably is not going to be a surprise, but China has a couple of different types of patents that they have. One is their truly quickie patent, which is only available for 5 years and doesn't really go through any review process in China. But then they also have another patent that is similar to the one that the United States has. Now, China, on that quickie patent, they have millions of patents that they are granting every year on that quickie patent. We have 600,000 patents that we receive, and we're granting about 330,000 every year. And that's similar for their 20-year patent in China. That's a similar rate. But the patent race is on because they do have this very simple quickie patent in China that is increasing numbers overall worldwide. And I think that it will continue to increase worldwide. Now, in the United States right now, our office, 50% of the patent applications that are being filed are from foreign filers. And so even though we've seen an exponential rise in applications, the exponential rise has really been on the foreign side. But has that decreased the amount of competitiveness for United States companies? I don't think so. Because what's happened is that overseas, because other patent systems have started to improve, the markets have also started to improve as well, and the opportunities for United States companies to enter into those markets are now increasing, and your ability to protect your intellectual property overseas has also increased.
And then we see a lot of that, especially when the EU went to their common filing system, and because it was able to enforce it similar to how you could enforce it in the United States. So if you know, the U.S. leads in being able to know when you could enforce something, and that created the economic value. And then you were able to spread into other countries and know that you had the same asset that's now enforceable in China, France, Sri Lanka, wherever. It allowed you to expand the amount of money that you can raise because you now had a global product versus just a simple product. So this is fantastic. Thank you so much for coming. Let's give Hope a big round of applause. If you're available for more questions, we'll go out to the lobby. We're going to have a drink. We are going to run, if you stay around for a second or two, we're going to run outside. We're going to run a little business card competition, and we're going to give away a gift bag for Inspire Park swag for people who are still here. So we look forward to catching you out front with it and grabbing a lovely beverage. And thank you again, Hope, for representing the USPTO today. We thank you so much.
Thank you. Thank you for having me.